Three, two, one, start. A legal tussle has spiraled up to this court seeking a quietus to the primary issues as to whether an employee is entitled to interest on the withheld amount of gratuity upon acquittal in the criminal proceedings pending against him on the date of his retirement, and as to whether the provisions of the Payment of Gratuity Act 1972, within bracket hereinafter referred to as the 1972 Act bracket close, would override the provisions of the Railway Services within bracket pension rules, 1993 within bracket hereinafter referred to as 1993 rules bracket close, stop para. The order dated 23/09/2022 of the Learned Central Administrative Tribunal, Kolkata Bench, Kolkata within bracket hereinafter referred to as Learned Tribunal bracket close, passed in connection with the original application 350/461/2020 is the subject matter of challenge in the present writ petition. Stop. By the said order, the Learned Tribunal refused the petitioner's prayer to direct the respondents to pay interest for delayed payment of the gratuity which was withheld for about 13 years from the date of his retirement, I.E. 31/12/2006. Stop para. The brief facts are that the petitioner was a carpenter under the railways. Stop. He joined his services on 06/03/1983 and was superannuated on 31/12/2006 from the post of technician / grade 2 / carpenter under the senior sectional engineer / NF railways / Barsoi. Stop. On his retirement, all payable retirement benefits were disbursed to him except the gratuity amount and the commutation value which was withheld on account of pendency of a criminal proceeding, being ST case number 303/365 of 2001 under section 302/307/380/452 of IPC before the Learned ADJ within bracket FTC, Third Court at Katihar. Stop. By a memo number DRM within bracket P dated 07/05/2007, it was communicated that the eventual release of withheld gratuity amount would depend on the outcome of the pending criminal proceeding. Stop. Consequent upon acquittal of the petitioner from the criminal charges by the judgment delivered by the Learned ADJ, FTC 3rd, Katihar on 30th June 2018, the respondents released the gratuity amount of rupees 1,00926 but without any interest, and the said amount was credited to the petitioner's account on 19/04/2019. Stop. The petitioner thereafter by a letter dated 28th January 2020 to the GM/NF/RLY Maligan within bracket Assam, CPO/MLG/NF Railways, DRM/Katihar/NF Railways claimed cumulative compound interest at the rate of 12% on the gratuity amount to be calculated from the date of his retirement and paid within 2 months after deducting the amount from the salary of the officer responsible who illegally withheld the interest despite within single quote no dues certificate decode, issued by senior sectional engineer / North Frontier Railway / Barsoi to the general manager within bracket personal, Katihar. Stop para. Unresponsiveness of the respondents to petitioner's prayer triggered him to knock the door of the Learned Tribunal, Kolkata, by filing an application under section 19 of Administrative Tribunal Act, 1985, being OS/350/461/2020 for a deduction upon the respondents to pay him cumulative compound interest at the rate of 12% over the withheld gratuity amount of rupees 100,926 payable from the date of his retirement, and no pay compensation of rupees 5,00,000 for his mental pain and sufferings and financial loss. Stop para. The learned tribunal decided the matter on 23rd09/2022, placing reliance upon the Rule 69 (1) of CCS Pension Rules 1972, and the application was dismissed, observing inter alia that the action of the respondents in withholding the gratuity amount cannot particularly be said to be on account of lapses on the part of the respondents. Stop para. Being aggrieved by and dissatisfied with the said order, the petitioner challenged it on the grounds that the learned tribunal failed to consider that a no dues certificate issued revealing that nothing was due to department and that no disciplinary proceeding was pending against him at the time of his retirement. Stop. The respondents withheld his gratuity, ignoring that gratuity can only be withheld to adjust the government dues payable by the employee. Stop. Thus, the respondents illegally withheld the gratuity amount and are liable to pay interest. Stop. In the said conspectus, the learned tribunal erred in law in dismissing the original application. Stop. Hence, this writ petition. Stop para. In the backdrop of the above facts and circumstances, Mr. Asim Kumar Niyogi, the learned counsel appearing for the appellant, vehemently contended that as per the section 7(3)(a) of the Payment of Gratuity Act, 1972 hereinafter referred to as the 1972 Act, close, the appellant would be entitled to interest from the date of his retirement. Stop. His gratuity was released on 19/07/2019, while he retired from service on 3/1/12/2006, and he was absolved from the criminal charges by the judgment dated 30/06/2018 of the learned ADJ (FTC) Third Court Katihar. Stop. Acquittal of the appellant proves his innocence, despite that his gratuity and commutation value was withheld by the respondents, citing the provisions of Rule 10(1) of the 1993 rules unilaterally without giving him an opportunity to be heard, and it was withheld arbitrarily in spite of the no dues certificate of the controlling officer. Stop. The denial of disbursement of gratuity is in violation of mandate of Article 14, Article 300(a) of Constitution of India, and the delay in payment of gratuity is attributable to the respondents. Stop. Such arguments as advanced were glossed over by the learned tribunal, and no finding was returned on the same. Stop. Such infirmity warrants interference of this court. Stop para. Drawing our attention to the contents of the representations submitted by the appellant, Mr. Niyogi submits that a co-accused in the criminal proceeding, namely Enamul Haq, was paid the gratuity amount during pendency of the criminal proceeding. However, a different yardstick was applied in case of the appellant, and such act stands out to be an instance of blatant discrimination practiced by the respondents. Stop. As a model employer, the state must conduct itself with high probity and candor and ensure that its employees do not succumb to the procedural rigmarole, particularly when the claim pertains to pensionary benefits. Stop. In support of the arguments advanced, reliance has been placed upon the judgments delivered in the cases of D.V. Kapoor versus Union of India and others, reported in 1994 SCC 314, Y.K. Singla versus Punjab National Bank, reported in 2013 3 SCC 472, and Jyotirmoy Roy versus the Field General Manager, Punjab National Bank and others within bracket unreported. Stop. Para. Per contra, Mr. Ajit Kumar Mishra, learned counsel, appearing for the respondents, contends that the respondents had acted in strict consonance with the 1993 rules and the claim of the appellant needs to be considered in terms of the said rules. Stop. The denial of payment of gratuity was valid and justified under Rule 10 within bracket 1 within bracket C of the 1993 rules. Stop. Furthermore, it was pointed out that under the 1993 rules, there is no provision towards award of interest in case of delayed payment of gratuity. Stop. Therefore, since gratuity had legitimately been withheld under the provisions of the 1993 rules, question of payment of interest does not occasion, more so when the instructions contained in OM dated 23rd February 2022 clearly speaks that payment of interest would occur only when the delay is attributable to administrative reasons or lapses. Stop. The appellant's gratuity had been withheld during the pendency of criminal proceedings initiated against him, and his entitlement to gratuity stood extended to such time as the said criminal proceedings were eventually disposed of. Stop. Thus viewed, the entitlement to gratuity stood extended to 3006-2018 within bracket IE, the date of the disposal of the proceedings pending in court against him, D-court. Stop. The respondents thereafter released the appellant's gratuity and the same was credited in his account on 19/07/2019 on his prayer made on 10/07/2018 after conclusion of the criminal proceedings. Stop. Para. Drawing our attention to an order dated 27/07/2017 of Central Administrative Tribunal at Patna passed in connection with OA 50/449/2016 prepared by the appellant, he argues that the learned tribunal denied to pass any order in respect of disbursement of gratuity or commutation in view of the provisions of Rule 10 within bracket 1 within bracket C of the 1993 rules, and as question of commutation would arise only from the final pension and not from the provisional pension. Stop. In view thereof, the same issue could not have been agitated in the present application and the same is not maintainable, being barred by the principles of res judicata. Stop.